assistance that can be offered is very welcome for those of us who are in the HR field. It's definitely created more questions than it's answered as they've tried to implement. Our presenter today, Mr. Blake Hamilton, is with Durham Jones Pinegar. Blake's primary practice areas are civil rights litigation and governmental entity defense. He serves as general counsel for the Utah Peace Officers Association and the National Institute of Jail Operations. As a conflict counselor for the Utah Fraternal Order of Police. His practice includes commercial litigation, complex criminal defense, and healthcare litigation, including licensing matters before the Utah Division of Occupational and Professional Licensing. Mr. Hamilton is a member of Durham Jones Pinegar's board of directors and is chair of the firm's governmental entity defense group. He was born and raised in Utah and presently serves as the city attorney for the city of Hilldale, and general counsel for the Hurricane City Police Department. In his free time, Mr. Hamilton enjoys spending time with his family, hiking, golfing, and snowboarding in Utah's beautiful outdoors. We always like it when we can get enough southern Utah people. But please welcome Mr. Hamilton.
Thank you very much. I didn't know I was going to be the last speaker or last presenter today, so got a little pressure here, and hopefully we can get you out a little early. Sounds like you're running ahead of schedule. I got a call, and they were like, "Hey, we're running ahead. Can you get here?" And I was just ready to jump on a conference call, so I tried to get that done as quickly as possible and get here. But it's a privilege to be here. I recognize that you folks are the ones that are dealing with this all the time, and so you have a lot of employment history, employment law knowledge, and I don't pretend to be an expert. I can just tell you what I read in cases, what I read with the new act that's come out, what I've read throughout the country and the trends that I'm seeing with respect to this specific topic. And hopefully we can have a good discussion. And to help facilitate that discussion, I've got stuff here to bribe you with. We have our new Durham Jones and Pinegar mints, and they may taste very familiar to you if you're familiar with the Utah mints, Utah chocolate mints. And then we also have the hand sanitizer. This is, as Ralph will attest, is much more popular probably with the correction folk, right? Presentations to correction individuals and personnel. But this, I just hope that we can have a discussion about this topic, because it's a very interesting topic. It's a topic I've been interested in for quite some time. I actually did a presentation for the Utah Municipal Attorneys Association back in 2016. There had been a bill proposed at that point in time about medical marijuana, and it hadn't passed, and everyone was kind of just poo-pooing its chances. And as I was looking throughout the country and kind of the national trends, I thought, we better not poo-poo this. I think it's going to be coming back, and sure enough, in 2018, we all know that there was an amendment, and it was voted on, and it was adopted, and then before it became ratified, or actually it got ratified, and shortly thereafter, a bill was proposed to supplant it, and that's kind of the lay of the land here in Utah now. And the reason why I think this is such an interesting topic is because it's a fast-growing industry. There's a lot of questions, a lot of concerns. I mean, since that happened in December, I've already had multiple issues where I've had Hurricane, for example. I drafted a policy for their police department. The Utah Peace Officers Association asked me to put out some kind of general policy statements. I've worked with the Highway Patrol and reviewed their policy statements regarding this, and I've seen it just kind of take hold. Everyone's just kind of wondering, this got enacted, what now, right? How does this affect me? How does this impact me? So we're going to try to talk specifically how it impacts you, but before we do, I kind of thought we'd talk about how we got here. I found this really to be quite an interesting slide. It was research done by the Pew Research Center, and you can see over a 50-year period of time, you can see the change, in public opinion regarding marijuana and the legalization of marijuana. Back in 1969, 84% believe that it should be always illegal. We should never legalize marijuana. And 12% believe it should be legalized. Flip that to 2018, and now 62% believe it should be legalized, while 34% believe it should be or remain illegal. So you can see how drastic that change is. Here is just a slide that kind of shows you kind of demographically who supports the legalization of marijuana. As you can see, millennials 74% of millennials believe that marijuana should be legalized. 63% from the Gen X generation, 54% from the baby boomer generation, and 39% from the silent generation. So you can see kind of just a generational breakdown of our population and who supports this. So why do people support it? What's the impact? Or why, what kind of would be the driving factors of that? I think first of all, you got to look at the economic factors. And when we talk about this, we got to really understand this is a $1 billion business. I mean, it is a $1 billion business. So if you look at this slide, and this again is prepared by the Marijuana Business Daily, and there actually is a publication that comes out called the Marijuana Business Daily. And when I got interested in this, I actually subscribed to it so I could receive their information and see what they were talking about. And it's really very, very interesting. But look there, you can see the economic impact that is projected in this industry. From 2017, where you're talking 20 to 23 billion, to 2022, where you're talking 62 to 77.4 billion. So there are a bunch of associations put together a study to try to determine what kind of commodities were what was the demand for certain commodities in our economy. And this is the study that they put together. So beer, as you can see, $111 billion business, or demand for it. Cigarettes, 80 billion. The estimated demand for recreational cannabis. What happened? That's going to make us start all over. Okay, there we go. But you can see the estimated demand of $50 to $55 billion. Video games, $36 billion. Donuts, 19. Firearms, ammunition, 11. McDonald's, 8. Netflix, 6.6. And this was actually the actual sales of recreational and medical marijuana in 2017, 5.8 to 6.6. And what does that show you? That at that time, if you remember, and we'll go through a slide that shows you how this became legalized throughout the country, but at that point, the majority of the states still hadn't legalized it. In 2017, there was a huge explosion in 2018 with the legalization of marijuana. And so you can see the demand is much greater than actually was sold in 2017. So, number of full-time workers in the cannabis industry, employment comparisons. Thought this would be interesting for you folks. This is what you deal with, is employment law and employment issues. But look at that, 216 telemarketers, bus drivers. Look where cannabis industry 2018 would be estimated at 154,400 employees. More cannabis industry workers than librarians, detectives, so those in law enforcement. Pretty interesting slide and graphic. So there's also a push to see kind of economically what would happen if the federal government ever decided, hey, let's go ahead and legalize marijuana. And so this was a study that was done by a financial group, and they came up to the conclusion that this is how many jobs would be created if the federal government decided to legalize marijuana. And you can see 1.4 million jobs would be created. So you can see kind of where this is coming from, why this is kind of swept throughout the country, and I'll show you some graphs here in just a minute, and you can really see how it really has swept throughout the country. But I figure, hey, you probably all don't know how this stuff is distributed. How do people actually partake and use marijuana? So here are some different delivery methods. You can see chocolate, you can see gummies, you can see pills, you can see patches, oils, okay, even drinks, right? So before we get into our specific state, I thought we'd talk about this conflict that we have in the federal government and with the states, because the states, while the states have moved to legalize, the federal government has held pretty strong, and depending upon the administration is really kind of where you see the rub. So the very first case I wanted to talk about was this Gonzalez versus Wright case in 2005. In this case, the DEA seized doctor-prescribed marijuana from a patient's home in California, where medical use of marijuana was legal. Okay, at that time, California had already legalized it, medical marijuana. In turn, a group of medical marijuana users sued the DEA and the U.S. Attorney General John Ashcroft, Ashcroft, arguing that Congress exceeded its constitutional powers to pass the Controlled Substance Act. And the Supreme Court, the United States Supreme Court actually decided this case, held that the Commerce Clause actually gave Congress the authority to prohibit the local cultivation and use of marijuana despite state law to the contrary. So because under the Commerce Clause, the federal government trumped here. And so the federal government law applied, and that's where it stood. As we know, the Controlled Substance Act specifically classifies marijuana as a Schedule I drug, which means in essence that it's highly addictive and having no medical value. That's the schedule it falls under federal guidelines. It declares the use, sale, or distribution of marijuana or any Schedule I drug to be illegal. The next case that I want to talk about was a 2001 case, and it's very similar to that 2005 case we talked about. Again, under California's Compassionate Use Act of 1996, the Oakland Cannabis Buyers Cooperative was organized to distribute marijuana to qualified patients for medical purposes. The United States sued and joined the cooperative, and its executive director arguing they were in violation of the Controlled Substance Act. The cooperative argued the medical necessity, but the Supreme Court held there is no medical necessity exception to the Controlled Substance Act prohibition on manufacturing and distribution of marijuana. Okay, so these are a couple different avenues that this was attacked, the federal legality of keeping this as a controlled substance one drug, and also, well, hey, we have conflict between state law and federal law. State law should control this issue, and you can see that the Supreme Court so far has not been persuaded in any kind of argument or avenue taken by any such group arguing that that conflict should go in favor of the states. So then in 2013, you had what's called the Cole Memo. Okay, the Cole Memo was drafted by U.S. Attorney James M. Cole. He addressed it to all the U.S. attorneys in all the states. So in 2013, we've had a few changes in our U.S. attorney here in the District of Utah. I don't remember who was the U.S. attorney at that time here in Utah, but it was addressed to him, and it basically said the DOJ would take hands-off enforcement approach to cannabis unless violating certain key principles. But then, just last year, in January of 2018, you can remember Jeff Sessions, the Attorney General at the time, basically revoked this and said he was giving the discretion to individual U.S. attorneys to enforce the federal cannabis or federal marijuana laws as they see fit. And that's really kind of where it stands today. The rescission of the Cole Memo, though, there has been enough time so that we've been able to look and see what impact that has had, and it really hasn't led to a significant increase, at least in enforcement, federal enforcement of the marijuana laws, or the marijuana law. No actions brought against ancillary players, attorneys, accountants, vendors, etc. And that was a big concern because you had a lot of states where it was legalized, you had attorneys advising, you had accountants, vendors that were tied up into this, and so how would they be impacted by this policy shift with a new administration? But there really hasn't been much, at least on the enforcement side. Okay, and this is a real thing. My law firm, we just did an internal presentation about the business of medical marijuana and kind of whether the legalities of actually having law attorneys work in that area and the ethical implications of having attorneys work in that area. I have a good friend who has a firm in Phoenix, Arizona, and his practice used to be very similar to mine, where he was doing governmental entity defense. And then he just happened to, at his very, very first firm he worked at, when he came out of law school, worked with a guy who now is the CEO and running one of the five biggest distributors of marijuana. And they're actually publicly traded on the Canadian Stock Exchange because Canada doesn't outlaw marijuana. And it's a booming business. And now 80 to 90% of my friends' practice, legal practice, is involved with medical marijuana, representing distributors and representing all those different kind of components of it. So this is really big business. You have the 2014 Warshbark-Blomner Amendment. Okay, it became law in December of 2014. You probably never even heard of it. I never heard of it until I put together these materials. It prohibits the Justice Department from spending funds to interfere with the implementation of state medical cannabis law. The DOJ initially interpreted this amendment to only apply to the state officials and not private individuals or entities. But eventually, U.S. District Judge Charles Breyer rejected this interpretation, and it has subsequently been rejected by multiple courts, including the Ninth Circuit and other courts. And then you had a States Act that was proposed last year. So this is proposed legislation from last year, strengthening the 10th Amendment through entrusting states. Act is a bipartisan bill. It was first introduced by Senators Elizabeth Warren, Cory Gardner. The bill was intended to replace and expand the Cole memo because they knew, look, last year we knew what happened. Sessions issued his memo revoking the Cole memo, and so the senators said, hey, let's see if we can pass some legislation. As drafted, the Controlled Substance Act would no longer apply to any person acting in compliance with state law related to the manufacture, production, possession, distribution, dispensation, administration, or delivery of marijuana. It already seems to have more bipartisan support this year. It didn't pass last year. It didn't even go up for vote. But it looks like it has more support this year, but its future still remains very unclear. It hasn't been passed. It isn't law yet. So let's just kind of take a look, at some charts here to kind of see how this happened. So the very first state, as you saw in the federal case law that we were kind of looking at, back in 1996, California started actually playing with the legalization of medical marijuana. And then by 2005, they actually had legalized medical marijuana. And you can see this, they were the first state in 1996 to kind of look at this issue and say, hey, we believe marijuana should be legalized in some form. And then you can see that in 1998, so just 2 years later, all of a sudden you're up to 4 states: Washington, Oregon, California, and Alaska. And then by 2000, you see more states. 2010, you've doubled again. 2012 was an interesting year because that brought on the implementation of actual recreational use in Washington and Colorado. And then in 2014, Alaska joined them, and there was other in the District of Columbia. And you can see that there was other states that at that point also decided to go ahead and move forward with medical marijuana. And then in 2016, you had more states. And then what happened in 2018 is you can see every state now besides Idaho and South Dakota have in some form legalized marijuana. Okay? And it can be in different distributions. You see some of them are only allowing for the hemp product, but the majority now are allowing recreational or medical use, as you can see throughout the country. Now, most states have generally adopted basically conservative policies or laws governing this. In essence, they want to be able to track from the seed to the cell of the plant and the product. They want to make sure that they are regulating pesticides and testing, advertising restrictions, and we'll talk about Utah. Utah has followed suit here with a lot of restrictions on advertising, pesticide regulations, etc. Packaging and labeling requirements, Utah has done the same. Controls on extraction and production techniques, and insurance requirements. Generally, $1 million of insurance, commercial liability insurance is required for these distributors and manufacturers. So let's talk Utah. Any questions? Sorry, I said I was going to bribe you with stuff, and then I haven't asked one stinking question. So any questions? So we can kind of see what's driving this. We can see how we've gotten to where we've gotten. So let's just talk specifically now about Utah, and then we'll talk specifically about you and how this impacts and affects you in your job. So House Bill 301 was passed by lawmakers on December 3rd, 2018. It replaced the Proposition 2 approved by voters in November 2018. It was a fascinating process. As soon as the amendment passed, I was up at the legislature on behalf of the Utah Peace Officers Association, and they're just amazing the activity that took place from the election to the time in December when House Bill 3001 was passed. Most elements of the program must be operational by March 1st, 2020, so next year. Prior to January 2021, not guilty, so this is in place right now. Not guilty for use or possession of medical cannabis, and if these three things are there, diagnosed with a qualifying condition, and we'll talk about what a qualifying condition. Anyone know what the qualifying conditions are? Anyone know where they can find the qualifying conditions? You've got a card on your computer you can look at and it'll tell you, okay? So we put together, there's a flow chart, a lot of law enforcement agencies have a flow chart, and part of that chart has just basically the list of qualifying conditions. Does anyone remember kind of what the debate was with respect to those qualifying conditions and some of the concerns?
Basically, if you get a doctor to sign off on it, good enough.
Okay, yeah, the concern was, hey, if I can find a doc, people are just going to go doctor shop and they're going to find a doctor. So we want to have some actual control, or that we actually want to know, there actually has to be a diagnosis of something for a doctor to be able to give that, right? And we actually, as a legislature, want to be able to control what would qualify. And a lot of that had to do with, I think, what is happening right now with the opioid crisis, right? We didn't want to get us in a position where all of a sudden we were just allowing the distribution of, like they have with opioids, where you have people that have fibromyalgia, these things that are, pain issues that are really, hard to have a actually objective test to be able to say, hey, yes, this person really is in pain, or yes, this person really does have fibromyalgia, so they should be given opioids. And that was a huge concern with the legislature, so they wanted to actually have this list, and fibromyalgia actually was one of them that they really went back and forth on whether that would qualify, and they actually came to some kind of a compromise, and we'll talk about what that compromise was. Also, you have to have a pre-existing provider-patient relationship. So that doctor shopping thing that we were talking about, they wanted to make sure that that wasn't happening. So it wasn't like you could just go and say, hey, I've got this condition, it's one of the conditions that are on the list, give me medical marijuana. I know that you're one of the doctors that actually prescribe it. Because there's only a certain amount of doctors that can prescribe it, and there's only, and some are going to self-select whether they're going to actually prescribe medical marijuana, and they can only have so many patients, as you'll see here in a little bit. So that was a concern. And then obviously it has to be a Utah licensed medical provider, and we'll talk about what that means under the statute, under the act. Cannabis is a medical dosage form and quantity, so you have to also, the cannabis has to be in that, and they've actually outlaid a specific quantity that you can have, and packaging. I showed you those distributions, how marijuana can be distributed. We'll talk about how most of those are not actually under the list of medical dosage, or medical actual dosage, okay? So people can't have candies, just gummies. And I actually have a funny story. So I'm the general counsel for a special service district. Beginning of the year, I get a call. They got an employee that tested positive for marijuana. Of course, what is he claiming? He first started trying to claim that it was medical. He clearly didn't comply with the Medical Act. Then he starts saying, well, it was just gummies. And I just said, you know, I'm like, look, we don't even want to go there. Gummies aren't even actually allowed under the act. And there was a lot of other reasons to terminate him. But area in a bunch of snow, sitting with him and his dog Willie, needing him to sign a release. But we got it done. But it was a kind of an interesting experience because it was just right after the act. He was making some claims that he needed this because this for medical reasons only. And luckily I'd been looking and really studying the act and knew how the act was supposed to work and was able to kind of say, hey, no, you gotta have a where's your doctor note, because obviously cards hadn't been issued at that point in time. Who's your doctor? Where's the prescription? Blah, 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 blah. And as we went down, it was pretty clear it wasn't for medical purposes. The other thing is, there's nothing in this act that protects people from liability under the federal laws or laws of other states. And that's important, important for you to remind employees. And we'll talk specifically what that means for you in HR, specifically with dealing with federal contracts and federal areas that your employees may have to go into, federal jurisdiction. Okay? So here are the qualifying conditions. HIV or AIDS, Alzheimer's, amyotrophic lateral sclerosis, I think I said that right, cancer, I'm not even going to attempt the next one, persistent nausea, Crohn's disease, or ulcerative colitis, epilepsy, multiple sclerosis, PTSD, autism, terminal illness with life expectancy of less than 6 months, rare conditions. And as I told you, the fibromyalgia, that stuff was being debated pretty heavily. They came to pain lasting longer than 2 weeks that is not adequately managed with other treatments. So for the person to qualify for medical marijuana, if it's because of pain treatment, they have to be able to establish, I've had pain for more than 2 weeks, and they have to also be able to establish they've tried other sorts of treatments before they would qualify. There's also other requirements like for PTSD, what would actually allow you to receive medical marijuana if you're claiming PTSD. We're not going to get into that. Any questions on that list? This is a list that you can just take and you can put in your workstation or just have handy so that you know what the qualifying conditions are. They're laid out right there in the statute for you. Okay, so section 2661A 106 then talks about what a qualified medical provider is, or who a qualified medical provider would be. That's a medical professional who can recommend a patient for treatment with medical cannabis. And it can be a Utah licensed physician, osteopathic physician, advanced practice registered nurse, or a physician assistant. But sometimes that advanced practice registered nurse and physician assistants don't have this privilege. You've got to make sure they have to be licensed to prescribe a controlled substance. And they must complete 4 hours of continuing education prior to registration. So they're actually going to have to register, again, as a medical marijuana doctor or qualified medical professional. And they're going to have to, again, receive 4 hours of training on that topic every 2 years to renew that ability. They're going to be limited to 175 medical cannabis patients. So again, there's going to be a cap on how many people they can actually treat with medical cannabis, or 300 if certified specialists in certain areas. So they have to go through certain certifications to be able to see more than or treat more than 175. And they must document a patient's record with a thorough assessment of the patient's conditions and medical history before recommending medical cannabis.
So why would a doctor do this?
Why would a doctor do this? A doctor would probably do this if they believe that it was in their patient's best interest and they had tried multiple other things. But I have two younger brothers that are doctors. One practices in Colorado, and he doesn't. I actually asked him about this a couple of years ago. It's been a couple of years ago, and at that point, he had ever prescribed anyone cannabis.
Yeah, I don't see a lot of doctors in Utah. I just don't. I just wonder, I see a lot of, people wanting to get marijuana. They're not being able to find a doctor because that's not doing it. Am I wrong on that, do you think?
Well, I mean, the way Utah has it so that it actually has to be prescribed by a doctor is very different. I mean, every state is different. Like, for example, in Arizona, you have a card. If you get a card, then you're good to go. It's amazing how many, 20-something-year-olds have cards, right?
I already have an employee.
You have an employee? Okay.
Yep,
So
he's
there's-
registered with us.
You already have an employee that's registered?
He has multiple sclerosis.
Okay. But that's, I think, why you would see doctors doing it is, look, we tried everything else. This person is in pain. Nothing seems to be working with the symptoms, like multiple sclerosis is a horrible, horrible, debilitating disease condition, and they're wanting what's best for their patient.
So I'm assuming it's the state that's supposed to be monitoring all of this to make sure that they're doing as they should be, is that right?
Yes. Yeah, and this last component right here, this last component is very similar to what is required like with the DEA and actually federally regulated prescribed medications, right? So I handled a large trial, was up in Brigham City. Dewey McKay, I was one of his criminal defense lawyers, and he prescribed it. A lot of that trial came down to the relationship that he had with certain patients and whether he had established this type of relationship, whether there was documents, and quite frankly his records were really sloppy, and that was one of the biggest problems of the case. He documented a thorough assessment of the patient's condition and medical history before I recommended it. So, any other questions on this? This is a good discussion.
So I have a question, maybe stupid, but so I was just asking, how do you know whether you, say you know somebody who has cancer that's maybe only has 2 months to live? I mean, is there a list somewhere that say these doctors prescribe? I mean, how do you know whether doctors in Utah are not prescribing marijuana?
Okay, that's a good question, and I don't think it's been addressed. There's no database that says these doctors are the prescribers of medical marijuana.
Okay.
And remember that what has to happen, again, for you, is you have to have a pre-existing provider-patient relationship. So you really, if you've got cancer, you've got to see if your doctor that you already are being treated by would prescribe it to you. You can't just say, I'm going to leave you and go elsewhere because I know so-and-so is. And if you do that, then they're going to have to develop that relationship before they can prescribe.
Because I think that may be a problem because people are going to go get it illegally because they're suffering or whatever, and so they don't know who actually to go to prescribe it. I mean, maybe I'm wrong, but if you don't know, people might go to other means to get the help that they need. If they don't know the doctors that actually are monitoring and prescribing it and watching over you.
And that's just kind of on a general philosophical kind of discussion. That's the concern with everything. So the crackdown on opioids. Well, if we don't allow doctors to prescribe this, then people are going to go to the heroin, and they're going to go buy street drugs.
Right.
I've got a niece that is a pothead that makes regular trips to Colorado. She is a master at this law. She knows every in and out about it. Ask your local pothead, they'll know which doctors.
I'm sure. Well, so there's that. Or that's probably true with opioids, right? If you wanted to know which doctor was the candy man who was handing out a bunch of opioids, you just go ask somebody on the street. Okay. But I thought you had your hand raised.
I had a question. One of the trainings I was to, I kept hearing that it wasn't necessarily a prescription, but a recommendation. Have you heard this? Was I getting this?
Well, 'cause
Is there a difference?
There's not a
or-
prescription right now available. There
So it
wasn't.
is a recommendation.
It's just a recommendation.
Is that kind of the same thing?
It's pretty much the same thing. It has to be documented. So even though it may not be written out on a prescription pad, it has to be documented.
And it's the recommendation that they would take to go get medical marijuana somewhere. And that's what they would provide, like an MRO if they had a positive drug screen. Okay.
And And right now, obviously, there's nowhere to get it here in Utah yet.
Right.
So,
So
I
they
mean,
would just hold their little paper and.
so that's why this is interesting, because again, you know, prior to, all this stuff's coming online in stages. So by 2021, March of 2021, all this stuff is supposed to be online. But before that, you legally can use medical marijuana, even though there's nowhere to get it right now here in Utah,
Right.
if this is compliant.
So if somebody had the documentation from their doctor, even though their doctor wasn't prescribing it, and then they went to Colorado or someplace where any kind of purchase is legal, and they got it in the approved packaging, they could bring it back to Utah and take it legally with no
Correct. Right
Utah
now.
law repercussions.
Right, as of January of this year, yes, that's correct.
So in that, is it okay if I ask just something else on that?
Yes.
In that scenario, if they fail the drug test right now, if that scenario, would the MRO be the one to make the ruling, or would that be something that makes it back to the HR department?
I would have it go back to the HR department.
But would we even have that opportunity? Would the MRO make the call and say it's a negative test? That's what I need, that's what I really need to know.
Okay?
Yeah.
So let's talk about that. So you say if it would even make it back. So I mean, you could make sure that it came back to your HR department. I mean, you could make sure that that was clear that, hey, if we have a situation where there is a positive drug test, and you're going to want to talk to your, and we'll get more into this, but there are different tests for cannabis that will show positive if it's for a quantity more than what is prescribed here. And what they tried to do, and again, with the limitations on the quantity and everything like that, was to try to carve out a way so that you could actually still do testing that would show positives for illegal use of marijuana.
We had one on.
I guess where I'm hung up a little bit, maybe I just need to have the conversation with our lab or with our testing facility, is that if someone tests positive for opiates right now and it's legal, the prescription's legal, that's something we never see. We just get the result that says it's a negative test.
It'll be the
And that-
same.
And so I guess what I'm asking is, can I tell the testing facility that we want all the positive marijuana testing?
Sure.
Would that be discriminatory? Because I've been told you have to treat it just like an opioid.
And we're going to get into that, and that is absolutely correct, except in your case, right now, yes, you could have that happen. You could make sure that you get that so that you can have the discussion with the individual to make sure that they're informing you, because this is coming online and you're going to have to change some policies, and you're going to have to change and to make sure that certain federal contracts and regulations are complied with as well.
Right. Okay, Mark, you're on that, right? Okay.
But that's a discussion, everyone in here is going to want to talk to whoever's doing the drug testing. And you're going to want to talk this through, this issue.
So we already had a CBD oil one come back, and it came back, and they of course put it as positive because he didn't have a medical card, he didn't have any reason, it was just the oil. But it was above the levels in which it should have been with the 0.03% that the CBD oil was supposed to be able to release, and so we ended up terminating the employee. So, I mean, you still receive, even when it goes to an MRO, it still comes back and gives you the levels that they have in their system.
And that's exactly, and so we'll get more into this, but again, and I don't understand all the science of it, but what I do understand is this, that the way that they've done this is they've tried to make it so that with these quantities, and we kind of listed out how much a person could have, and we're going to get into how it can be distributed, but with the way it's distributed and the quantities that they're supposed to have, that there's ways to test so it'll show if they're using it illegally. And there's still repercussions for using it illegally. Yeah. All right. Any other questions on that? Okay, so we've gone through who a qualified medical provider is. Let's talk about the dosage forms. And again, this is where we're talking about the testing. So the dosage forms are tablets, capsules, concentrated oils, again, but their quantity, I mean, if there's a higher level, it'll still test, you'll get that number and be able to, and do certain things with it. What?
Ours was that the CBD oil that you can obtain in Utah on the Farmers Act, what his levels exceeded what could have been unless he was basically bathing in it. So it proved that he brought it over from state lines, which he wasn't supposed to be doing because he didn't have any medical card or something like that.
Liquid suspension, topical preparation, transdermal preparation, gelatin cubes, unprocessed cannabis flower in blister pack of 1 gram or less, wax or resin if 2 of the above are not effective. So they already have to be able to establish that they tried other distribution methods. Smoking of cannabis is not permitted, so this is not, you can't just go and roll yourself a doobie in your basement and you're good. And it's not permitted, but vapor devices are, okay? Some vapor devices are going to be allowed. Edibles such as candies, cookies, brownies, and unprocessed flowers outside of blister packs are not permitted. So Utah resident patients can apply for the medical cannabis card with their qualified medical provider. So that's what they would actually receive. The Utah Department of Health evaluates the applications and issues the cards within 15 days. And patients under 21 must be approved by what's called the Compassionate Use Board that will be set up. Cards include patient card, caregiver card, provisional under 18, patient card, guardian card. Okay? Those are the types of cards that will be issued. Those living within 100 miles of cannabis pharmacies, in one 12-day period, they may purchase no more than doses to last 14 days, 56 grams of unprocessed cannabis, or 10 grams of a total composite THC. So it's the levels of THC, again, that can be tested. Living over 100 miles of cannabis pharmacy, in one 28-day period, they may purchase no more than doses to last 30 days, 113 grams of unprocessed cannabis, or 20 grams of total composite THC. So they broke it down by mileage away from the pharmacy. Of course, the pharmacies we'll get into in just a minute. Any questions on that? Purchase restrictions, or the cards, or the dosage?
So Blake, on that, the restrictions of how much they can have at one time or purchase. I'm from a local health department, and we've been trying to evaluate what traffic that's going to be through our front door every day, and some of the numbers we're looking at based on number of cards issued in other states. In Weber County, we expect 200 people a day through our front door as that goes into effect. Because if they would allow people to have more than a 14-day prescription, then it would be fewer people, but that limitation of only having 14 days worth of
So how are you tracking that, or how are you coming up with that number?
we've looked at the number of medical cannabis cards issued in other states and tried to compare number of cards to county population size. So it's kind of a guess. We really don't know what to expect in Utah, but it's just what
Yeah, I
we're
mean, I think the
seeing.
demand is going to be there, but I think because of some of the procedural requirements, that a health department's going to a health department to get your cannabis is a little different than going to a shop that has, the green cross on it, right?
We kind of guess, for Weber County, we're guessing about 2,000 prescriptions at any one time. And if it's a 14-day supply, that would be about 200 people a day.
That's interesting. And so, there is going to, one of the fascinating things to me was the fact that they decided the way to distribute this would be through health departments and then, these 7 to 10 pharmacies. That's different than that's very different, way to kind of distribute this stuff. And I kind of worried about how that was going to impact specifically health departments in counties, because they're all of a sudden going to have a lot of people coming to them that they normally wouldn't have coming to them. So that would be one of the little interesting things to track, is to see the impact that has on your health department. So how many health departments here are going to have to, or do we have that are going to be dealing with it? Yeah, so half the room is going to be very impacted by this. Any other questions or comments? Okay. So cannabis pharmacies. There's only going to be 7 pharmacies, 7 to 10, but that just depending on the demand for it. They may up it to 10, but 7 pharmacies available. They must have a licensed pharmacist registered as a pharmacy medical provider with UDOH. They can sell cannabis products only in medical dosage form, medical cannabis devices, or educational materials. Only card holders over 18 years old may enter. Okay, so it's, I guess it's going to be kind of like when we had video stores and there were certain parts of the video store that only a 18-year-old could go in, I guess. But this is the whole pharmacy itself. So these pharmacies are going to be just designated pharmacies for this. Employees registered as medical cannabis pharmacy agents and passed criminal background checks. They're not going to be, again, a lot of the regulations I said are kind of on advertising and packaging. No advertising, but may include signage, a green cross, name, and hours. Secure entrance, security system, follow product labeling requirements, and there are really tight labeling requirements with respect to how these products are labeled. They cannot be within 600 feet of a residential or community zone location. Inventory control system to track cannabis, 8 plant to sell. So they want to be able to track that again. That's one of the things most states really like to make sure that they're tracking it from seed all the way to the sale.
Has the state actually set up anybody to actually oversee all these regulations?
This hasn't come online yet, so the question was whether the state has already set this up. The answer to that is, if they have, I'm not aware of it. But that will be rolled out as the timing slide kind of laid out.
It's in process.
It's
The
definitely in
Department-
process.
Yeah, the Department of Agriculture has that responsibility for the inventory control. And they have staff that they've hired, they've created a division of the Department of Agriculture, and they're putting all of that together now.
So get to know Carrie Gibbs.
I
Yeah.
just wonder if it's going to fall on the local law enforcement to do all the enforcement of this, so.
The question here is this going to fall upon the local law enforcement to do the enforcement of this? They're not going to be the ones enforcing this, the type of pharmacies. Obviously, they may work in conjunction with the Department of Agriculture to go in and do certain undercover stings, I guess, but much like the DEA works with local law enforcement when they're looking at certain doctors or pharmacies. But this time you'll be working with the Department of Agriculture. Any other questions?
The Department of Health will do all the licensing and permitting of the pharmacies themselves, but the Department of Agriculture is the agency that will track from the seed to delivery at the pharmacy.
So the Department of Health, so that in that way it's a little bit different. A lot of times with doctors, or pharmacists, you have the Department of Licensing that gets involved, and I do some of that administrative stuff as well. And so here it's going to be the Department of Health. Any other questions or comments on this? Okay. So there's also going to be the state central fill pharmacy. This was part of the act as well, and this again is kind of one of the unique features of Utah. Must be operational by July 1st, 2020. Closed door pharmacy that ships, so this is not like a place where you can go off the street and walk into. This is a closed door pharmacy that ships patient orders to one of 13 local health department locations for customers to pick up. So besides these 7 or 10 independent pharmacies, they're going to basically be distributing medical marijuana through your health, or through 13 local health departments. Sounds like Weaver's one of those.
But is this indicating that the health department ones would only be orders that are pre-ordered, pre-verified, and it's just them picking them up?
That's correct.
Is that right? Okay.
Yeah, we're being told that the local health department will receive a package from a courier. We hold that package and then check ID for the person when they arrive to pick up the package. We won't even know what's inside the package. We won't accept any payments. And we're not allowed to give any educational information or anything like that. We just essentially check ID and hand a package over. There's a time frame for which we can hold the package, and if they don't come and pick it up, then we have to send it back to the central pharmacy.
That's when this all came out, that this is the way it was going to be distributed. That was the question. Obviously, is how much do we want state employees involved in something that actually violates still federal law, right? And so that's fascinating how they're going to be doing that.
What if our health department is within 600 feet of a residential zone location?
That only applies to those pharmacies.
Oh, not the pharmacies.
So this is dealing with the 7 licensed pharmacies, the 7 to 10 licensed pharmacies. The health departments are, they've already been selected and they're going to be used in the way he's describing. I didn't know that it was going to come in a sealed package like that. That's interesting.
That's the state central field pharmacy, not the local health department.
Okay, any questions about that? Again, it's going to be all medical cannabis pharmacy requirements, orders placed throughout the qualified medical provider, electronic verification system, or phone. So when it says it meets all medical cannabis, I think this is the question you were just asking your neighbor, but that means this pharmacy, the central, it's not talking about the health departments. Electronic payments are going to be required, written counseling information included in each shipment, and contact information for a pharmacy medical provider for counseling. So I guess they will have the materials already in that box. So the health department's not going to be handing out the materials, but they're going to be in the sealed box. So here's really the big implications for you, and this is really, I hope we can spend some time having a discussion about this. There's not a lot really to talk about as far as topic areas, but as I kind of thought about it with respect to you individuals, this is what you got to first know the law. Second, don't discriminate, and we'll talk about what that means. You got to comply with HIPAA, so you got to treat this as a medical condition. Adopt clear policies, and that's one of the things we'll talk about, how to do that with the federal regulations. So the state statute actually gives some governing kind of principles here. And the first one that they give is in 2661A 111, and that is that the state or any political subdivision shall treat an employee's use of medical cannabis the same way they treat employees' use of opioids or opiates, unless doing so would jeopardize federal funding, a federal security clearance, or any other federal background determination required for the employee's position. So what does that mean? What does that mean to you?
So Blake, can I throw a twist in that? Because it's an issue the local health departments are discussing, is we may not have employees using, but with a medical cannabis card, but we're forcing employees to hand the product out. And most of the local health departments are funded 50% or more of their budget by federal grants. And so we feel like it's a huge risk for our federal money.
And that is the biggest rub. Like, I mean, so speaking not to health departments, one of the things I'm going to tell you as counties is that you should be looking at all your federal grant money, all your federal contracts, and making sure that employees that are going to be using medical cannabis are not going to jeopardize that funding, those grants, or in any way are going to be impaired in performing their job duties. I don't know how health departments are going to deal with it. I mean, and that is, again, that was when this all started coming out, that was one of the big questions I had, was how is that going to work with federal grant money and federal funding for health departments if you then have these employees distributing, controlled substances under, that are federally outlawed.
That's the listening question.
That's the big question you have. And I think what they're trying to do is, in a lot of ways, protect you, and I guess that's why they're doing this sealed package that I haven't heard until today. And I don't know. I mean, I think that's where the state is really going to have that's a potential area where the state's really going to have a fight with the federal government.
Where it's talking about any other federal background determination, would that mean that if a position was going to be involved in these federal contracts, federal security clearance, that it would have to have a separate drug test that would identify that? Because under normal circumstances, if they were within the legal limit of medicinal, then HR should never really know about it. But if they were in this type of position, would it then require a separate type of drug test that would then identify, no, you didn't pass your background, your federal background for this job? Is that where it's going with this, or?
That's where it's going with this, but you're gonna have to put the employee on notice, and we're gonna talk about that here in a minute. Like, so if they're going to be, if there's restrictions to their employment because of federal contracts or federal regulations, and they, in their employment, are going to be governed by those federal regulations, and you can see there's going to be a conflict with them being a medical cannabis user, you have to notify them of that, which means you should notify everybody of that. Like these positions here require you to go into federal jurisdiction, or there's federal regulations that are implicated here. You are, just so that everyone is aware of that, and just have that language there about the Medical Cannabis Act. But every HR director should be looking and asking their legal departments to look at their federal contracts and look at what federal job or what job descriptions actually implicate federal regulations. And then making determinations of how to revamp your policies, basically to take this into consideration. Any other questions? I mean, that other guidance is pretty clear, right? Like, you're supposed to treat them like they had a prescription for opioids. So that obviously has its limitations, right? They can't come and be impaired if they're going to be running heavy machinery, all that kind of stuff, and you just have to spell that out in your policies. So before assigning duties to an employee relating to the medical cannabis, a state or political subdivision employer must give an employee or applicant written notice. This is what I was just talking about, this notice requirement. This is under 2661A 111. That the job duties may require the employee to engage in conduct which is in violation of criminal laws of the United States. Okay. And that by accepting the job, the employee may not object or refuse to carry out the assignment that may be in violation of the criminal laws of the United States with respect to manufacture, sell, or distribution of cannabis. So you want to make sure that they've been put on notice with respect to that.
Can the employee say, no, I'm not going to do that?
Then if that's one of the qualifications for the job, then they don't comply or they don't meet the job requirements. And then that gets into the discussion about the ADA, and we'll have that in a minute, but fortunately, violating federal law is not an ADA disability.
What if they're existing employees?
So existing employees?
Yeah,
Yeah,
can't
well, that's what I was
defer me.
thinking.
I can see upon hire that I tell them that this is, but if I have an existing employee who's a tenured employee, and how do you deal with that? That you say your new job is to hand out marijuana, and they say no.
Fire.
That
I think that would scare me if you fired him.
No, that would scare me.
It's just like Johnny said earlier today about the employees that heard about the personal use of government property and decided to retire because of the risk to their pension. It's the same thing. We're telling our health department employees they have to hand this out, and their biggest risk is they could lose their pension because they could be charged with a federal crime. And so we don't know how to tell an employee if they refuse. How do we tell an employee it's a tough luck, it's your job, and you have to put everything at risk?
That is. If you can find ways around it, find employees that are willing to do it, that's obviously the way to go. If you can't, if you have existing employees that are not willing to do it, then you've got to maybe see if there's, you know, an accommodation that can be made. I don't know.
I don't know, you can take it to an extreme and get a little paranoid with it, but they're gonna develop a list. All of our employees have to be certified to handle the medical cannabis. So the state will have a list of all the employees that a federal agency could request a list of and know exactly who to go after if they chose to do it.
And then you just got to recognize that hopefully the state at that point is going to step in, because the state is the one that set up the system. I mean, this is a state-ran system.
I mean, I would think that they would have some.
They would have to.
They would have to back your employees.
Absolutely. I mean, or else the state is setting themselves up potential huge liability.
I don't know if it's really related, but we had a guy that we had to let go because he went to Colorado and came back high. And in doing research on that investigation, there was a case, DirecTV versus somebody, where they fired the guy because he was using medical marijuana, and he appealed it, and it ended up going up to one of the higher courts. And because it's still against federal law, the termination was upheld. So, you know, if we end up terminating somebody because of this, if it ends up in the court system, you're going to get overridden because it's still against federal law.
And that's kind of what I was saying with respect to the Americans with Disability Act, and we'll talk about that a little bit more. Just because you use medical marijuana doesn't mean you have what can be defined as a disability that would exempt you. Any other questions? I mean, this is where the biggest rub is, right? Like, I mean, especially for those counties that it's the counties that have health departments that are going to have their employees handing out these substances that are against the law federally, and how to make sure that you get actual employees that are willing to do that and will pass the certifications. And that's where the state law comes in conflict with the federal law. But again, you can go back, and there is, sorry, we're going to go back quite a ways here. You have the Rorschach-Blum Amendment. And again, it prohibits the Justice Department from spending funds to interfere with the implementation of state medical cannabis law. I think there's a pretty strong argument that would be interfering with the state's implementation of this. If the federal government was to come after it, the Department of Justice, U.S. Attorney's Office was to start prosecuting your employees for distributing this. So I think you have that act, that's a federal act, okay, that in essence gives you some protection. Any other questions on that? Okay, so we'll go to knowing the law. Only legal use of cannabis is protected under the law. It's still legal in Utah, again, for smoking and edibles. I gave you my example of the case, Special Service District, with the edibles. Card holders possessing higher quantity than what is allowed, that's still illegal. So, know what those legal limits are. That's why that's important for you. Card holders possessing cannabis in the form of other than medical form. So that's why we went through how it can be actually distributed. Card holders selling or sharing with others. So just because you have a card as an employee doesn't allow you to go and say to your colleague there at work, here, you should try this. You're complaining of hip pain. You should really try this. This will really help you. And again, driving under the influence.
Will the person get their card revoked for wearing it?
Absolutely. Consider amending the policies to specifically address the requirements of the Act. So this is where you can go through your policies and make sure it complies with the Act. Your drug testing, particular positions of concern, i.e. federal funding, heavy equipment, dangerous weapons. So obviously law enforcement, you want to be able to address that with law enforcement. You want to address it with maybe like your roads department, like, hey, just like an opioid, we can't have you, taking opioid prescription medication and driving this type of machinery. So if you're going to be taking marijuana, you need to notify us so that we know that you should be using this machinery. Working while impaired. Again, the same laws apply with those that are using opioid prescriptions. Drug testing is still permissible. Again, as I said earlier, everyone in here should speak with their drug testing lab about what you are testing for and when, so that you have an understanding of the science behind this. Consider distinctions between types of THC, and say, look, here's what the law says. I mean, these drug testing labs are going to know more about this than you or I am going to know about this. So talk to them and make sure that they can still test, because you want to make sure people are still following the law. And if they're not following the law, you still can terminate. Consider whether random testing or some other frequency is appropriate. And then continue following your anti-discrimination practices already in place. Again, you got to treat cannabis cardholders the same as you would an employee using prescription opioids. Avoid asking questions about their cardholder status unless directly relevant to their job duties. So again, this is using the equipment. If you notice job performance that you're concerned that there's impairment, those type of things, then you can obviously ask them. Illegal drug use is excluded from the ADA claims. I've brought this up a couple times now. As defined by federal law, so marijuana use is not protected under the ADA. But remember, comply with the ADA as it relates to other disabilities a cannabis cardholder may have. Because remember, they have to have one of those issues to actually even receive a medical marijuana card, right? They have to be being treated for, and the thing that they're being treated for may fall under the ADA. So even though their use of medical marijuana doesn't give them ADA protection, their actual physical condition may. Are there questions about those areas? No questions? Okay. So when in doubt, consult your legal counsel. Every one of you have good county attorneys. I work with a lot of your county attorneys and know them well. And then seek resources from the state of Utah. And these are a couple of really good websites that you want to be able to look up. helputah.gov, medical cannabis. There's a whole section there. Gives you, because the act itself is really dense, like most acts are. Like for example, let me just show you. So here's your act. This is your Medical Cannabis Act itself right here. That's pretty thick, right? But then if you go to these websites that I just showed you, that are listed there, you can pull off answers to frequently asked questions. You can pull off fact sheets that just basically go through the act and give you the facts, just bullet point facts so that you can be aware of those facts that are important. So you really should use those as good resources for you. And if there's no more questions, we're going to be done. We're going to be done pretty early. So is there any questions at all? All right, well, it really was a privilege to come and speak with you about this. I'd be happy to be a resource for you. I mean, I know you all have county attorneys. I do work with a lot of your county attorneys, but if you wanted me to come out to your county, you wanted to talk to your county attorney, have me come out and do this presentation, I'd be happy to do that. And we could, this presentation, I changed it. There was a zoning section, there was a law enforcement section, so I can add those sections back in. And again, I was kind of a hypocrite. I apologize, I didn't throw a lot of these out. But if you want to get some of this swag, feel free to come and grab some of it before I leave. Thank you.
All right, then we're done for today. And we'll start up at 8:30 tomorrow morning.
That's what I want, is some music songs.
They
Just hang out with them, I'll be back tomorrow.
Can't remember who else.
Same with you.
Some health departments, the same day.
Absolutely. Those chocolate mints are really good. Yeah, chocolate mint.
And we have,
That was better than my.
We'll lead the way.
they work right across the street from health department.
There you go, see? My question is security. Are you going to have an armed storage door or maybe a lock?
We kind of started out thinking.
I love that.
In California and she was working.
I know. No, you never had.
I hate that.